You all may be seated. Call number 329142. Let the record reflect that the case is styled the state of Texas versus Rachel Marie Primo. Ms. Primo is present in court with attorney, Mr. Wright Kimler, and the state is present with Assistant District Attorney, Mr. Tommy Coleman. Let the record also reflect that the jury is now present in the courtroom. Ladies and gentlemen, at this time, I will read to you the charge of the court containing the law applicable to this case. Ladies and gentlemen of the jury, defendant Rachel Marie Primo stands charged by information with the offense of possession of a controlled substance, alleged to have been committed on or about the 31st day of October 2019 in Jefferson County, Texas. The defendant has pled not guilty. Our laws provide that a person commits an offense of possession of a controlled substance if the person intentionally or knowingly possesses a controlled substance. Under our law, clonazepam is a controlled substance. Possession means actual care, custody, control, or management. You are instructed that mere presence at the locations where drugs are found is insufficient by itself to establish possession. Controlled substance means a substance, namely clonazepam, including any adulterants or dilutants. The term includes the aggregate weight of any mixture, solutions, or other substance containing a controlled substance. Adulterant or dilutant means any material that increases the bulk or quantity of a controlled substance, regardless of its effect on the chemical activity of the controlled substance. A person intentionally or with intent, with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person's act knowingly or with knowledge with respect to the nature of his conduct or the circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person act knowingly or with knowledge with respect to the result of his conduct when he is aware that his conduct is reasonably certain to cause the result. If the jury believes or has a reasonable doubt that the evidence was obtained in violation of any provisions of the Constitution and or laws of the state of Texas or of the Constitution or laws of the United States, then in such event, the jury shall disregard any evidence so obtained. Now, if you find from the evidence beyond a reasonable doubt that on or about the 31st day of October 2019 in Jefferson County, Texas, the defendant, Rachel Marie Primo, did intentionally and knowingly possess a controlled substance, namely clonazepam, in an amount less than 28 grams, including any adulterants or dilutants, then you will find the defendant guilty as charged. Unless you find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant. And information is the means whereby a defendant is brought to trial in a misdemeanor prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the issue of guilt of the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial. It never shifts to the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The fact that a person has been arrested, confined, indicted for, or otherwise charged with an offense giving rise to no inference of guilt at his trial. The court does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is evidence or is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and the weight to be given their testimony. But the law you shall receive in these written instructions, and you must be governed thereby. After you retire to the jury room, you should elect one person or one of your members as presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify your verdict by using the appropriate form attached hereto and signing the same as presiding juror. No one has any authority to communicate with you except the officer who has you in charge. During your deliberations, in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider any, nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You must refrain from the use of any cell phone, PDA, examples, BlackBerry, iPhone, etc., or any other communication devices during jury deliberations. Internet use, text messaging, and/or instant messaging is prohibited or forbidden during deliberations. After you have retired, you may communicate with this court in writing through the officer who has you in charge. Do not attempt to talk to the officer who has you in charge, or the attorneys, or the court, or anyone else concerning any questions you may have. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate form attached to this charge and signing his or her name as presiding juror. After closing arguments of counsel, you may retire to consider your verdict. And the last form of this document is titled verdict. If your verdict is, we the jury find the defendant, Rachel Marie Primo, guilty of the offense of possession of a controlled substance as charged, then the presiding juror will sign the top line. If your verdict is, we the jury find the defendant, Rachel Marie Primo, not guilty, then the presiding juror will sign on the second line. Okay. Does everyone understand? Okay, at this time, we'll move to closing arguments. Each side will be given 10 minutes. State, are you ready?
At this time, Your Honor, state we're waiting this right to open, but reserve is right.
Okay, Mr. Kimler, are you ready?
Yes, Your Honor, may I proceed?
Yes, Mr. Kimler.
Ladies and gentlemen. Mr. Coleman gets to go after me because he has the burden of proof in this case, so he'll be the last one you hear from in the case. And of course, I've tried to anticipate some of the things he may argue, but there may be some things that I missed. So perhaps if you would, in your deliberations, you might want to ask yourself, well, if that defense lawyer could have answered the prosecutor, these are some of the things he may have said, because I can't anticipate everything Mr. Coleman's going to say. I think I have a pretty good idea. This isn't really hasn't been an extremely long or complicated or difficult case. It doesn't mean it's not important. There's just not a lot here for you to remember. Now, the Judge Holmes has instructed you about your deliberations and this unanimous decision. I don't want any of you to take that you have to return a unanimous decision. If each of you go back into the jury room and engage in good faith deliberations in consideration of the evidence and considering whether the state's met its burden of proof, and both your reason, your common sense, your conscience, what you think the correct result is, be that guilty or not guilty, then you've achieved or you've met your obligations, you've met your duty. It's not some sort of obligation or responsibility that you have to return a unanimous decision. If that would mean one or more of you have to surrender what you think to be the appropriate vote based upon your reason. If you can't agree, then it's what's called a hung jury, and this trial will just come back and do this again with another. So it's some sort of failure. It's not required to return a unanimous decision. Just to vote your reason, your common sense, your whatever you believe the correct outcome to be. That's the burden that you have, your obligation. Now you'll notice in these instructions, Judge Holmes hasn't instructed you what proof beyond a reasonable doubt is. He's told you what it's not. It's not proof beyond all possible doubt. It's not absolute certainty, but he hasn't told you what it is. Again, each of you, when you go back and you're considering the evidence, you're going to have fixed in your mind what that standard is, how high the burden that is, because that's the standard that you're evaluating the evidence by. So each of you are going to have that fixed in your mind, how difficult the burden is, how high the burden is. Since it's not defined, you could have 6 different versions of it, and none of you would be incorrect in it. But you may have differing ideas about what level proof beyond reasonable doubt right. I would simply suggest to you that, again, what we talked about in voir dire is that the result of a conviction is punishment. So how sure do you have to be? How high of a level of proof do you need to meet the standard of beyond a reasonable doubt to convict somebody of a criminal offense and subject them, in this case, potentially to going to jail for it? How much proof, how sure do you have to be? That's the level of proof beyond a reasonable doubt, what that standard is to each of them. Now, I'm moving a little fast because I only have 10 minutes, so I'm going to bear with me. The court is giving you an instruction here, an additional instruction, and this is found in section 3, the last paragraph of section 3. And Judge Holmes has instructed you regarding your power as a jury to pass on the legality of the search in this case. And that's what this paragraph here really tells you, that if the jury believes or has a reasonable doubt that the evidence was obtained in violation of any provision of the constitutional laws of the state of Texas or the constitutional laws of the United States, then in such event, The jury shall disregard any evidence so obtained. The evidence that the court is referring to is a chronology that was found as a result of a warrantless search of the vehicle. As we established, the rule is that there should be a warrant when vehicles are searched. There are many exceptions to that requirement of a warrant, a search warrant, to search a vehicle. The requirement of a search warrant protects all of us against unreasonable searches and seizures. That's why it's there, but because it's a vehicle, there are many exceptions to the warrant requirement that don't apply if we're talking about a house or a residence or something like that. There are many exceptions to the warrant requirement when we talk about a vehicle and not a residence. One of those exceptions is if the officer who is conducting the search develops probable cause and his legal probable cause to search the vehicle. That's the exception that the state has urged in this case to provide a legal basis for this search, to make this a legal search. What this provision is, it allows you to pass on the legality of that exception. Was that a legal exception to the warrant requirement? And the state bears the burden to convince you beyond a reasonable doubt that it was. And if you will recall from the evidence, the officer urged that he detected the odor of an illegal substance emitting from the vehicle, the odor of marijuana. Ergo, and therefore, that gave him probable cause to search the vehicle. Probable cause being presence of some sort of illegal substance. That's the exception to the warrant requirement. Before you can consider the clonazepam, the illegal substance that he found, you have to believe beyond a reasonable doubt that that fact existed, that the fact of an illegal, the odor of an illegal substance emitted from that vehicle, that being marijuana. And you heard testimony from the lab analyst that in order for something to be marijuana, it's not enough that it's a green leafy substance from the cannabis sativa plant. It has to contain 0.0% THC, tetrahydrocannabinol, or more.
That's objection, Your Honor, to misstatement of law. He said it must contain 0%.
0.03%.
That's right.
Okay.
You get 0.
Oh, I
Okay.
apologize.
Objection sustained.
Correct. It's 0.03%. It has to contain, for it to be illegal, it has to contain 0.03% THC or tetrahydrocannabinol. If it's less than that, it's illegal. It's hemp. It can look exactly the same. It can smell exactly the same. Well, the illegality derives from it being a 0.03% or above. The lab analyst told you that she didn't analyze any green leafy substance. So she's not in a position to say whether it was an illegal substance or illegal. There's been a failure of proof by the state in asserting this exception to the warrant requirement that there's probable cause of illegal activity. There is no illegal activity that they've been able to establish because they haven't established beyond a reasonable doubt that it was in fact marijuana that the officer smelled. If they wanted to do that, they could have taken the substance and had it analyzed at the lab and shown that it was 0.03% THC or above. Without that, there's a failure of proof. And according to what the judge is instructing, there was no exception to the warrant requirement because there was no probable cause, because there was no odor of illegal substance emitting from the vehicle. They haven't established it. That's their burden.
Your Honor, that's a mistake. I object. That's a misstatement of law. It says that the court has instructed this jury through the charge if there wasn't a probable cause.
Objection
That's a
sustained.
misstatement of law.
If I stated that,
And jurors, questions and comments of the attorney do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorney that is inconsistent with the law contained in this charge. You may proceed.
what I'm saying is they haven't established, the state hasn't established that there was an odor of an illegal substance emitting from that car. They haven't established, they're giving evidence that it was marijuana, the odor of marijuana emitting from that car, and not something that was 0.03% THC or less emitting from that. That's their burden. And that's what I'm saying, what the law is. I believe that's what the law is. They have to establish that exception on probable cause before that search is legal, which they haven't done. Therefore, you shouldn't consider the evidence in clonazepam that was seized as a result of the search, and the verdict should be not guilty. Now, if for whatever reason consider it, if you find the search was legal, there is additional proof in the record to show that there is reasonable doubt, because as the court's further instructed you, it's not enough that somebody possesses something, somebody asserts care, custody, control, or management over something. It has to be knowing possession. And the court's.
Mr. Kimler, you have 2 minutes.
Yes, you're all heard it. Person acts knowingly or with knowledge with respect to the nature of his conduct, and that's here in paragraph 3. A person has to know. This criminal would have had to have known that that substance was in her purse before she can be convicted. She testified. She didn't have to testify. She did testify and told you that she didn't know it was in her purse. And again, how do you evaluate the credibility of witnesses? You can consider, you can believe all, part, or none of what anybody testifies to. The judge has told you that. But how do you know somebody's telling you the truth? Well, you compare their testimony to known facts, partly, and see if there's any kind of contradiction. First of all, the first observation I would make that substantiates or corroborates Ms. Primrose assertion that she didn't know that was in her purse is the fact that she's not under the influence of it. You can look at her behavior, you can look at her manner of driving, what the officer told you.
You have 1 minute.
The effects of that substance are not evident, or Your Honor, I'd ask for a little bit of additional time.
No objection.
Okay, you may proceed.
I'll try to wrap it up. But her behavior, her demeanor, her cognitive ability, her functioning is consistent with not being under the influence of that substance. Secondly, you can look at her explanation of how the substance may have gotten into her purse. All right. She was obviously excited in the video. She was looking for her lost dog, was in a state of agitation. She testified that when she was putting things into her purse, she was in a hurry to try to go find the dog. And in fact, she didn't even know that her driver's license. That's consistent with what you see on the video, and consistent with her not having knowledge of this substance in her purse is that the manner in which it went into the purse was that she was in a hurry, that she wasn't being careful, and that's how it ended up in there along with her driver's license. She asserts, and I don't know that this was actually played for you all on the video, but you can watch it. It's on there, I believe, that for the officer that it was her sister-in-law's substance, not her. She's consistent.
Objection to that, the misstatement of what that video was showing.
Objection sustained.
We didn't watch it, and I don't know if you have to watch it yourself to see what she said, but she consistently maintained that she didn't have knowledge of that substance. And you're gonna have to look at it and see, you can look at what she says on the video to see about that. You can look at her demeanor, you can evaluate her credibility as she was on the witness stand itself, and ask yourself, do you think that she's showing indicia of reliability? Is she a believable witness? It's important to realize too that the fact that she's testified doesn't somehow shift the burden on the defense to prove to you who do you believe more in this case. It still remains the burden of the state to prove to you beyond a reasonable doubt that she possessed it and that she had knowledge of it and that the search was legal. So looking at the evidence, I would suggest to you that her testimony was credible. She didn't have knowledge of this. You don't have to believe that beyond a reasonable doubt. You just have to have a reasonable doubt whether she did. And looking at this in its totality, I ask that you return a verdict of not guilty because there is reasonable doubt here about her knowledge of the substance being in the purse, and also about whether or not the whole search itself was legal. And again, it's up to you as members of the community to set the standards for what is going to constitute a legal search, the interaction between law enforcement and the citizens, how that's governed. And it's obvious that we don't want law enforcement just to be able to search people at their will, at their whim, that there has to be a legitimate exception to the warrant requirement, and that's urged by the state to justify a search. So I hope that you take that seriously and know that you will, and ask that you return a verdict of not guilty.
Mr. Coleman, you get 12.5 minutes.
May it please the court.
Yes.
Mr. Kimler, ladies and gentlemen of the jury, I want to begin by thanking you on behalf of the Jefferson County District Attorney's Office for your time and attention, and especially your patience today. I know we had to wait for a while before we got started, but we were progressed through. We were working on some things specifically related to the jury charge today. And I want to talk to you about the jury charge. You have all the law that applies in this case in this jury charge. Mr. Kimler has done a masterful job of defending his client, of advocating on behalf of his client. Part of what some defense attorneys like to do is a little bit of what I like to characterize as smoke and mirrors. What he would have you to believe is that Sergeant Romero, when he detects the odor of marijuana, which precipitated the search, is obligated to, by his nose alone, by his smell alone, he's obligated to say, that smells like more than 0.03% of THC to me. That's what he wants you to believe. You can rest assured, if that was the law, it would be in this jury charge. That is simply not the law. Sergeant Romero was not required to discern, to make a distinction between what was hemp and what was marijuana.
I would take that's a misstatement of the law. It has to be probable cause of illegal activity, and that requires that distinction.
Mr.
What I said was he's not required to make a distinction between hemp and marijuana.
Okay,
That's the distinction between legality and illegality. He is required to make that.
okay, ladies and gentlemen of the jury, questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorney that is inconsistent with the law contained in this charge. You may proceed.
Thank you, Your Honor. You don't have to believe me. This is all the law you need. The judge read the charge to you. You don't have to memorize it. You'll get a copy of it. You can take it back and look at it. This is all the law you need. And if that was the state of the law, then Sergeant Romero had to make the distinction by his smell alone on the side of the road between hemp and marijuana, then it would be in it. It is simply not, ladies and gentlemen. Here's the thing. There is one thing that Mr. Kimler and I agree on, is that this case, while it's a short case, while it's a misdemeanor case, it is important. He said that, and I will agree with it. It's important to the defendant, it's important to the district attorney's office, but even more than that, it's important to our system, our criminal justice system. Because small cases, just like big cases, murder cases, sexual assaults and robberies, they're part of this system we call the criminal justice system. And in order for this system to work properly, in order for people to have faith in the system, it must be treated equally, and it must be applied consistently by all of the people and all the participants and all of the players in the system. Sergeant Romero did what officers do, is he was enforcing the traffic laws when he saw a violation of the traffic law. And when he detected an odor of marijuana, he investigated further. Sergeant Romero initiated charges in this case. That's his role in the system. The crime lab tested the clonazepam, and they came in here and testified about the process in which they used to testify, so that you can have faith in the fact and render a verdict based on the fact that you can rest assured it was clonazepam. Our office, when the charges were referred to our office, we did the best we can to select the appropriate charge to pursue and to ultimately prosecute the case. I've done the best job I think I could do in order to prosecute the case. This judge has made certain that applicable to this case has been followed. And lastly, ladies and gentlemen, you're a part of that system. You've been a part of that system since Tuesday when you were selected. I'm asking you, not because I say so, not because any other reason. You follow your oath and do it when you talk about it. That's your role in this system we call the criminal justice system. Your oath is to follow the law, and the law has been given to you in the security law. Another thing we talk about in jury selection is you don't have to have a legal background. You don't have to be kind of trained. You have all the tools you need, your common sense and your life experiences. Defense counsel would have you go down a rabbit trail about warrantless searches and all these archaic legal terms. But really, at the end of the day, what it comes down to is what you have heard. Does it sound credible? Does it make sense to you based on your common sense? That's what it comes down to. And what I'm asking and what I'm submitting to you, the evidence has shown that it was the defendant's vehicle. She was the only person in that vehicle that the clonazepam was found in her purse, next to her ID, next to marijuana that she was willing and has admitted to possessing.
I'm objecting that's outside the scope of the evidence that it was marijuana, because it wasn't tested. He's not in a position to say it was marijuana because it's tested.
It was-
Okay, ladies and gentlemen of the jury, questions and comments of attorney do not constitute testimony and must not be considered as evidence. You must disregard any statement of the attorney that is inconsistent with the law contained in this charge.
Thank you, Judge. Remember what we talked about, common sense. That's what it comes down to. Don't get back there and get distracted on all these legal terms and archaic phrases. Does it make sense? Like we talked about in jury selection. You know, I guess someone could argue that aliens did. You know, we talked about that in jury selection. I could argue that I was a professional basketball player in a previous career. What does your common sense tell you about that? In this case, this notion of Lauren Pruitt, all of a sudden after 3 years, that name comes up. You think that it's Lauren Pruitt's marijuana. This Lauren Pruitt who has not testified before today. This Lauren Pruitt who has not provided any statement. Anything for you other to use to base your verdict on, other than the word of this defendant? I submit to you that your common sense, be your guide on that. Let's be clear here. The defendant. Oh, another thing. The video, you're welcome to watch it in evidence. On that video, I submit to you, she will say to the officer that marijuana, the clonazepam belonged to her friend. She didn't say it belonged to her sister-in-law, Lauren Pruitt. She didn't say that on the video. Again, don't take my word for it. It's on the video. Here's the thing. She's not on trial for being a bad person. Okay. I've heard it said before, the good people can make poor choices. And in this case, I submit to you that Ms. Primo has made a poor choice. She made a poor choice that day. But again, bringing this full circle back to our system. Our system functions when we hold people accountable. And I'm asking you to hold her accountable for her poor decisions. Her poor decision that day, based on the evidence that has been presented to you in this case. Follow your common sense. And I'm asking you to return a verdict based on the evidence in this case. Finding Rachel,
Okay, ladies and gentlemen of the jury, both the state and the defense has rested this case. They have given their closing arguments. This case will go to the jury. And on this jury, we have actually 6 people that's actually on the jury, and then we have an alternate. The person who is the alternate is not allowed to go into the jury room. They have to stand by in case something happens to one of the jurors, then they will go in and participate in the deliberation. And the person that is the alternate in this case is Sharon Luggins Hughes. Ms. Hughes? Okay. Now, Ms. Hughes, you can stay in the courtroom or in the hallway or in the back at the chambers. That decision will be made up by you. Now, the other 6 individuals who are on the jury, Mr. Porter, who is our bailiff, I'm going to give him the charge, and he's going to escort you into the jury room. And the court will be in